Before we begin, I'd just like to remind everybody today that I found out during the break that we have 150 people viewing this program online. And there have been questions coming in, and I want the questions to continue, but the questions for the people, for the benefit of those watching online, we're going to save those to the end to make sure we get through all the material. We have enough time to do that. Also, for those that are attending online, you're probably waiting for a code. So the code for the first segment, for the first panel, was 3JD, as in the 3rd Judicial District, 3JD. Made it short and sweet for everybody. Okay, so now in this segment, we're going to talk about the process, a tutorial, if you will, for practicing attorneys. This may be a Herculean effort to get through this in 50 minutes because we have a lot of material to cover in a very short period of time. And if we don't get to everything, perhaps we will have a part 2 next October to cover the rest of the material in the evolution of the law, because by then we'll definitely have some Court of Appeals decisions to sink our teeth into. So I'd like to welcome the panel for this segment. We have Lisa Perlman sitting at the end. She is the Chief DVSJA START Unit in Brooklyn District Attorney's Office. So thank you for making the trip up here, Ms. Perlman. We have Stephen Sharp, who's the Assistant Alternate Public Defender here in Albany County. We have Karen Portlock, who is a partner at Gibson, Dunn, and Crutcher. And then we have Veronica Reed, a supervising family court attorney in the Albany County Public Defender's Office. So thank you, all of you, for sacrificing and donating your time today for this program. First, I'd like to start off what I think, Mr. Sharp, I'm going to ask you first to speak with respect to the process.
Good afternoon. A lot of things to cover, brief period of time to cover them. This is basically the process, what attorneys need to know on both sides in terms of those that are incarcerated in Department of Corrections that qualify under 440-47 and those that are pending sentence and can file or make a request for a hearing under 6012. This is the difference between the two. There's two paths. There's an application for resentencing for those that are incarcerated in Department of Corrections, and then there's a request for hearing alternative sentencing under Penal Law 6012. So we're going to discuss both of those. Kate already stole this material from me. Thank you, Kate. So we'll keep moving. 440-47. The first step of the process is to request to apply for resentencing. That is, the person can find at docs. There are criteria that you need to establish to be eligible to make that request to apply. One is you have to be confined in Department of Corrections. If you've been released, the statute does not apply to you. You have to be, as discussed by Kate already, serving a sentence of 8 years or more. The offense has to have been committed prior to August 12th, 2019, which is the effective date of the statute. So if somebody was committed an offense in 2020, 440-47 does not apply to that person. And the offense also has to be eligible for an alternative sentence under 6012, which, as discussed earlier by Kate, the exclusions, the few crimes that are inapplicable. You obviously have to be eligible under that. Right to counsel. The legislature, in enacting this legislation, made it very easy for people to get counsel. Courts do not have the option like they may in a traditional 440-10 or 440-20 context. Once they make this request, the courts must assign counsel. What happens after that request is made is they are notified by the court. They are either then permitted to submit an application or it is dismissed without prejudice. Can somebody appeal if it's dismissed without prejudice? Don't know the answer to that. The statute does apply for an appeal by right, but the language may not be broad enough to cover dismissal without prejudice for a request to apply for resentencing. Courts will answer that maybe in the future. So application for resentencing. What do you need to establish as the applicant? You need to establish that at the time of the offense, this person was a victim of domestic violence, subjected to substantial physical, sexual, or psychological abuse, and that the abuse was inflicted by a member of the same family as defined in 530.11, which is a very broad definition of who can qualify under that. That's all they need to establish in the application to ultimately advance to a hearing. And I'm going to talk about corroboration in a minute. That's required. One thing I wanted to very briefly discuss that any attorney should know is to counsel your client about the risks of going forward with an application for resentencing, particularly where it becomes uncomfortable for somebody to file this, is if they still have a direct appeal pending, or if they have a 44010 motion alleging ineffective assistance that may warrant itself in a hearing. And because necessarily, when you are filing this application for resentencing, your client is essentially admitting to guilt, okay? Because they have to establish, ultimately, as we get further at the time of a hearing, that the abuse that they suffered was a significant factor for why the offense was committed. So it's important to counsel without risk. I've had to do that a couple of times where people who are incarcerated ask about the statute and they have a direct appeal pending. And the answer is you need to understand that if you're successful on your direct appeal, if you go forward with this application, you're putting in an affidavit admitting to guilt or testifying at a hearing and making admissions, that obviously may be very problematic for you if you win your direct appeal. So definitely make sure you counsel your clients as to the risks. Corroboration is a requirement for under 440.47. It requires at least two pieces of evidence corroborating the claim of abuse. One piece of evidence must be an official record or a sworn statement from a witness. Official record, police report, pre-sentence investigation report, those types of things. There's actually in the statute a list that's not exactly exhaustive, but it needs to be, as I describe it, an official record or a sworn statement. If you have somebody who witnessed the abuse and you get an affidavit from them, if you get the abuser to write an affidavit, for instance, you need two pieces of evidence corroborating the claim. What the law means about corroboration is unknown at this point. I'm working on a brief right now, should be filing it soon, that discusses what level of corroboration must be required, whether it's a stringent standard, whether it's the minimal standard, and whether, for instance, an affidavit from a client counts as corroboration, which sounds incorrect, but there's some lower courts that have held otherwise. And one of the things about evidence corroborating the claim, if you have a statement to a pre-sentence investigation report, that comes from your client sometimes, and that can be held as corroborating evidence. So it's going to be an interesting issue to litigate going forward. This is more conversation for other people who are going to be up here in terms of trying to track down that corroboration. And what sources of information do you look for? Do you use investigators? Do you use experts, social workers? That type of investigation is going to be talked about by other people. What information the district attorney's office is looking for. As already discussed, a number of these have been consented to by district attorney's offices. All right. So what does the resentencing application include? It includes a notice of application, your attorney's affirmation, and the exhibits and attachments, the corroborating evidence, affidavit from your client, everything that you want to put in that resentencing application. Ultimately, the court determines compliance or non-compliance, meaning the application itself, they're not making an actual determination on whether there's merit. They're simply looking at whether or not the application complies with the statutes, those requirements that I already listed out for you, or whether they're not in compliance. If in compliance, the court then shall, there's no discretion here, order a hearing in accordance with Penal Law 6012. If non-compliant, the court dismisses the application without prejudice. If the court issues a decision saying, this is the error that I see, you don't actually have to go through with an appeal if you can remedy that. whether it's another affidavit, another piece of information you may have held back, the client and you help your client resubmit that application. 6012, it's not really laid out as dramatic as 44047. It's you make a request at a hearing for a hearing on this before sentencing. And that's what you do. The hearing, the court must consider oral and written arguments made by counsel, must consider testimony from witnesses from either party. Both the defense and the district attorney's office has the opportunity to put witnesses and take testimony. Consider all relevant evidence. And of note, reliable hearsay is admissible. For those who practices in the criminal arena, sort of like a SORA hearing, reliable hearsay is admissible. So you can rely on putting into evidence a pre-sentence investigation report. You don't have to call the probation officer who actually did that and heard statements from your client or from somebody else. Reliable hearsay is admissible. The court may also consider any fact or circumstance relevant to a new sentence and the applicant's record of confinement. And that's another thing that all attorneys should do. And both in the context of a 6012 hearing, but also for the 44047, is you should be taking steps to get your client's record of confinement. If it's exemplary, what they've done in there, all of those things can be considered by the court if they agree that you meet your requirements, which we'll talk about in a little bit, and as to whether or not this person should get a reduced sentence. The hearing determination, what you need to establish as an attorney at the hearing, whether it's, now we're talking basically both. 44047, there's a hearing that's granted. 6012, there's a hearing that's granted. What does the applicant need to establish? At the time of the offense, the applicant was a victim of domestic violence, subjected to substantial physical, sexual, or psychological abuse inflicted by a member of the same family as defined in that broad statute. At the time of the offense is the subject of recent litigation and decisions from the appellate divisions. Somebody else is going to speak a little bit more about that as where that time of the offense matters. Is this something that can apply for somebody who suffered significant abuse 20 years earlier to the offense? And I know Lisa and other people will talk about that. Such abuse was a significant contributing factor to the applicant's criminal behavior. That certainly is one of the most litigated and maybe in dispute topics when bringing these applications. And then finally, having regard for the nature and circumstances of the crime, history and character condition of the defendant, a typical sentence would be unduly harsh. That is a judge's discretion. That's why you want to do everything you can to put your client in a good light at the time of this application. The other thing that is interesting in this context of a typical sentence, what didn't get mentioned in this first panel is it's actually a huge difference alternative sentencing can make for the clients. It can be a very serious reduction in time. We're not talking about, okay, here's a year off, here's 2 years off. It's significant, the impact that it can have. And even within the resentencing, the judges have discretion within ranges to do that. But it can make a huge difference on behalf of your client. What the standard of proof is at the hearing determination is a preponderance of the evidence. That's the standard of proof. Ultimately, a court will issue a determination, and it's usually very straightforward. Either the order denies resentencing. The courts must include written findings of fact and the reasons for the order, much like a SORA hearing where a number of courts throughout the state don't make findings of fact and it creates issue for appeal. The courts have to issue written findings of fact and the reasons for the order. If you happen to have a situation where a court is not doing that, please make sure that you address that with them, that they do, so there's not issue in terms of an appeal in the event of your client not being successful. It is appealable as of right if an order denies resentencing. The statute sets that forward. Or there's an order granting resentencing. It is appealable as of right by the applicant. So even if you go through all this and your client ultimately gets a reduced sentence, but it's not the minimum, they can appeal as of right, arguing that they should get even a lesser sentence than what the court below imposed. Can the people appeal? That is, I think, an open question. So under 6012, they can appeal. The judge is making the determination following either a plea or a trial. They had a hearing. The judge, that's in their discretion under the statute. They can't appeal. There's no right to do that. The interesting question is whether the people can appeal following a order granting resentencing after 440-47, because the statute is broadly written enough that I think that the people can probably credibly make a claim that they can appeal. But that is not directly in the statute saying that the people also have the right to appeal. But if you read it, I think a fair reading of it means both parties can do so. But that's certainly something that may come up in the future. So, all right, reached my time. I made it. There you go.
Thank you, Mr. Sharp. Thank you. Now, much to my, I think, surprise, there was an earlier statistic that was put up on one of the slides that there was a very large number of applications that were actually consented to by the district attorney. So in order to get more of that to happen, let's ask our district attorney, Lisa Perlman, to come up and see what is it that the district attorney is looking for, or what can the defense counsel put in these applications that would make the district attorney's office more likely to come to some type of consensus or agreement, so all of these hearings are not necessary.
Thank you, Judge Fisher. Good afternoon, everybody. And I do want to thank you for inviting me here today because as Judge Fisher just talked about, this really, it's really important that the prosecutors be part of this conversation because this should be a conversation. And I can speak to what goes on, of course, in the Brooklyn DA's office, but for across the state, prosecutors' jobs are to make sure that justice is done. And it is my belief that the DVSJA is just another tool at getting to what justice is and getting to what the actual truth of a case is. And as we're learning through things like the DVSJA, sometimes the truth is just larger than the crime itself. And I think that it's really important, and I encourage you not only to open a conversation with the prosecutors in the various counties that you're working in, but also to acknowledge that often because of the parameters of the DVSJA, heinous crimes happened. And I read motions sometimes and the crime is buried in maybe, 126 paragraphs of affirmations. And there's no need to do that. I want to really just submit to everybody to think that two things can exist, that we can start to consider what was happening for a defendant in their life and in the context of a relationship, and that can serve as mitigation, but that a horrible crime happened. And I believe that will result in more receptive prosecutors, better conversations, and a better unpacking of what the truth really is. And so validate the crime. It's okay to say that a horrible murder happened, a baby was killed, or a person that was outside of the alleged abusive relationship died. The prosecutor, and I'm saying this hoping or that some of my colleagues are listening, but also because I believe that I'm speaking mostly to defense attorneys, to appreciate that the prosecutor has an obligation also to those original crime victims and their surviving family members. And so when it seems that they're pushing back, there are really complicated conversations that they're going to have to happen, that they're going to have. And that does not mean that they're not going to be open to the information that is illuminating another aspect of what took place. But to that end, approach the prosecutor earlier rather than later in a process, particularly in open cases where you're starting to believe that there might be a reason for a 60-12 sentence and you want to pursue a 60-12 hearing. It's going to be more fruitful to have those conversations before a prosecutor has sat down with a victim or that victim's surviving family members and discussed the parameters of plea negotiations and talked through numbers and years with them, only to come back and say, oh my God, it turns out that there's all of this other material. And now I know we were talking about 20 or 25 years. We're really maybe going to cap it out around 5, because I believe that Stephen talked about the dramatic distinction between the sentencing guidelines. For be violent under the DVSJA, the maximum is 5 years determinant as opposed to 25 years. For murder, it's 15 years determinant with 5 years post-release supervision as opposed to 25 to life. They're dramatic differences. And sometimes that relief is absolutely merited, but they're really different conversations that we need to have. So I also, for prosecutors that may be listening, I will encourage you to, if you have one of these motions that are brought to you, to bring colleagues in your office into the conversation that have an expertise in domestic violence prosecution. In Brooklyn, my unit lives in our domestic violence bureau, where we are schooled in and have experience with what coercive control looks like. But as we are seeing over and over again, these aspects of coercive control can come up in a robbery of a third party where there would be no role traditionally for the dynamic of coercive control. In terms of some sort of what I want to say, some tips to sort of make for more compelling motions when you're coming to the, if you're trying to get across that finish line, particularly if you want to get, when I say finish line, I mean consent of a prosecutor's office. Things that we're looking for are really unpacking the difference between prong 1 and prong 2. Prong 2 is significant contributing factor, and it's my belief that the legislature took the time to include that prong because the existence of substantial abuse, of victimization by an intimate partner or a member of their household does not by itself make out the DVSJA. And I look to the legislative intent. I look to how the legislative history talks about how they wanted to ensure relief for people that may not make out duress, may not rise to the level of a justification because maybe they don't make it out legally, or maybe they didn't raise it because they couldn't. And by couldn't, I mean they didn't even realize it was going on for them, or they weren't ready to face it, admit it, talk about it. But they were in some capacity acting to protect themselves. And I think that some of my colleagues here today might have other opinions, but I think that acting to protect oneself from abuse presupposes that that is going on at the time of the offense, that that relationship exists then, so that it has to be more than a trigger. And so if you can unpack that significant contributing factor, don't collapse prong 1 into prong 2. Sometimes there's well, they were a victim of domestic violence. We've made that out through multiple domestic incident reports, multiple police, multiple eyewitness accounts that this was going on. And the crime happened. So obviously it was a significant contributing factor. It's not obvious, it needs more. I will tell you that it has been helpful more often than it has not been helpful, extremely helpful when I have gone and interviewed applicants that are in prison, obviously in the resentencing posture, the 440, 47s. There's something that I always refer to that I learned what's between the paragraphs. And of course, this is done with counsel present. And I think that that's valuable. I think that there's always something that I walk away with that's just not on the paper. So if you have a motion that you're filing for an applicant and you think that you have a prosecutor that you want to say, hey, my client's open to talking to you about this, I think that more often than not, that's a benefit. I've certainly, and I talk, to Kate about it all the time, there's very many resilient, amazing people that truly merit this relief, and that resilience, that ownership of the circumstances, that between the paragraphs nuanced what was going on for them, not why did you pick up the knife, but what was going on when you picked up the knife, or what, that they can't really articulate it in the paragraphs, usually comes across in these in-person meetings. Keep in mind, of course, and I think that this is obvious, but I really want to just draw your attention to what a huge responsibility and a heavy lift it is to disturb an otherwise legal sentence in a particularly heinous crime. And so we have this responsibility, and we're looking at reentry plans, and we have to ensure the public safety. And we typically are off a case for years and years when reentry comes up, right? This is way down the line. And so I encourage you to educate the prosecutors on what a robust reentry plan can look like. And by that, I mean, do more than say I have letters of reasonable assurance from a variety of institutions, because when we read those letters, we really look at them and they say, we're happy to speak with this person. Should they come up for parole, should they be released, we're happy to meet with them. That doesn't ensure a bed, that doesn't ensure housing, that doesn't ensure employment. So the letters of places that are willing to provide reentry services can be given more and less weight depending on what they're really saying about the client. I've had a number of conversations with defense attorneys where the plan is for them to go back to live with their mother. And I'll say, well, you spent about 20 paragraphs talking about the abuse of the mother in their childhood that then set them on a path for abusive relationship after abusive relationship. Can we come up with a different plan? That one sounds like you're sending them back to the people that were complicit in their trauma. And we've been able to work around that. So think that through. You want to come to the prosecutor and say, we have a plan, and it's a thoughtful plan, and it's going to set this person up for success. In terms of, and I'm learning along the way as I have more and more of these conversations. I have the benefit of working in a county that has a high volume of these types of motions, so I see more and more. But I will suggest that what I've learned about reentry is, or programming, I should say, programming and disciplinary history is worth knowing where there's room to create a narrative. If somebody doesn't have, let's say, the academic inclinations to get their bachelor's degree and 2 master's degrees while they're serving a 20-year sentence, maybe they did something else that was elite within the circumstances. They were in an honor dorm, or they were in a program that's considered, a reward. Maybe, I've spoken with recipients of this relief that said that acting classes, like this was your case, where an applicant said that her acting class set her up to have the confidence to go on job interviews. And so rather than being, maybe economics would come off the page as more impressive, it was really an acting class that was going to provide a life skill that was really relevant. In terms of disciplinary history, as prosecutors, we'll look, and sometimes we count the tickets and we'll say, oh my God, this person had, 25 tickets and they were tier 3s, but break it down and point out that those tickets happened in the first 3 or 5 years of 12 or 15 years of incarceration. Start to make a timeline and say, you know, it was in year 2 of their incarceration that they actually got involved with this group and had a breakthrough and realized all the trauma and were able to finally admit that they did commit this crime and admit their guilt, and they became less filled with rage. They worked through the trauma, and the tier 3 tickets dissipated, and there was a quiet time for 10 years of no disciplinary history. And then there was a ticket, but we got the report, look, it was really, they had contraband, but it was jewelry or something like that, and line it up so that the prosecutor isn't just counting tickets, but that sometimes there's a story to be told. And sometimes there isn't, and you know that's indicative of other issues. But I think that those are some places where we can all work together to get a more robust application and a better sense of what the truth and the right outcome should be.
Okay, thank you. Now I'm going to turn the question over, or ask Ms. Reed to come up from the Public Defender's Office to give us what the process is like for the applicant. And we've heard some overlay with what the DA was looking for, but why don't you tell us what it's like?
Thank you. I was actually, as a long-term defense attorney, I'm actually pleasantly surprised at how aligned what I'm going to say is to what Lisa said. Yeah, it was a little disconcerted, but actually happy from the grand scheme of things, right? Before I forget, though, I do want to pick up on something that Steve had said with respect to the resentencing applications that are denied without prejudice. I can't remember if it was a phone call from Kate or it was a phone call from Stephanie, because it was years, feels like years ago now. It was right after the DVSJA went into effect, and I guess I was fortunate to have the first DVSJA application for resentencing in Schenectady County. It was denied without prejudice. And so I kind of just set it aside. But luckily, one of you called me within the 30 days and said, did you file an appeal? And I said, well, it was denied without prejudice. And you said, rule of thumb, file it anyway. So thank you. So I just want to share that rule of thumb with your resentencing, if it's denied without prejudice. As a practice, you should be filing the notice of appeal anyway. Yes, it's an unresolved issue of law, whether you can or can't, but file it anyway. What I want to focus on are three big things that I've learned the hard way. So I want to share those things so that you don't have to learn them the hard way. The first one is your third prong proof, which is largely how your client is doing on resentencing while they've been incarcerated. If you were doing the hearing and your appellate counsel will thank you, get your general releases and your HIPAA release to docs, get those records, and please put together on the record robust proof of how your client is doing. If substance abuse was an issue related to the underlying crime, then please get records that show that the defendant has been clean and sober for 15 years or however long it's been. Please get proof that your defendant has participated in different programs, that they don't have disciplinary history. If they do have disciplinary history, exactly what Lisa was saying, a narrative on the record, proof on the record that how well your client is doing. One of the things that statistically, and Kate talked about this, your DVSJA, your successful DVSJA applicants, the violent crime that they commit is connected to the domestic violence experience that they have had. So it's really important to show the history in incarceration, their success in incarceration, because if they are no longer subject to the domestic violence that was the substantial cause of the violent act that they committed, right? It's an inference. You got to have that proof. Related to that, have your defendant testify about their plan for release, their housing plan, their income plan, their family supports. I get appeals to do where defense counsel in the hearing has not put any proof in the record that the defendant has a plan for release. It's things as simple as, I want to hug my grandkids. My mother passed away from Alzheimer's while I was incarcerated, and I want to be out and released and be part of Alzheimer's advocacy, okay? That stuff is very important, and have your defendant testify to that during your DVSJA hearing. The second piece, and this is, I owe Judge Fisher a debt of gratitude for this. I was telling her, I put a Post-it note on my mirror. Credibility of defendant. You have to assume, and it's a very safe assumption, that your DVSJA applicant is not going to be seen as credible in the county court. Period. She's not. He, she, they is not going to be credible. And we can spend hours talking about the structural failures of why your applicant isn't going to be credible. But here's what my Post-it note says, is you have to deal with the environment that you are in, solve the problem. Solve the problem. Your applicant is not credible. So how do you solve the problem of credibility? What do? You corroborate everything that your applicant is going to say. Everything. Ideally, with contemporaneous records, tear the trial file apart. Find everything. Go track down trial counsel. If they tell you, oh, trial files are in a box in the basement and they've been chewed on by rats for 15 years, go get it, because there may be notes in there. Remember, the evidence is anything that's relevant. There may even be a forensic evaluation that was done, but it didn't prove justification, so defense counsel threw it in a box in the corner. That's golden, right? You want that. You have to have corroborating proof. One of the appeals that I just lost, it was that the inferences of coercive control, right, could not be corroborated. The witnesses that testified at the hearing had completely different testimony at the DVSJA hearing than the statements that they gave contemporaneous with the crime 15 some odd years ago. And guess what? Defense counsel never put on the record why the statements in the DVSJA hearing for the witness were completely opposite of what was contemporaneously said, and did not bring in an expert to explain the 15 years ago, we didn't understand coercive control. Goodness, 15 months ago, we could arguably say we didn't understand coercive control, right? So the statements that were taken that night of the violent act, right? They're not going to support coercive control. So you got to make sure that you have those records. the third and most important, and learned this one the hard way, have a plan or process for what to do if you are successful in your resentencing application. Now, right, every good appellate attorney, we have our outline of what to do, right? If we ever win and our client gets to go home, right? We do this and we do this and we do this. Okay, if you win, from personal experience, if you win your resentencing on appeal, especially when it's the Thursday afternoon before Christmas, okay, your brain explodes, all right? If you don't have that piece of paper, you will forget everything, even though you think you won't, you will. So write it all out. And I will tell you the most important thing that you need is you need your certification from docs. Okay, you're going, so you win, all right? Your client is going to be resentenced. You call the on-call judge. You've got your appearance scheduled. You've got to have the certification from docs. I will tell you that the only person that they answer the phone for on the Thursday afternoon before Christmas is Alan. And only Alan, he has the cell phone of somebody. So yes, but you need that certification. And the certification takes time. And I know that they tell you that, oh, you have to mail it in and you can't fax it in, and that walk it to docs. And oh, by the way, it's not docs on the campus, on the state campus, it's docs downtown. So make sure you write all of that out. You're going to need your appearance from county court. You're going to need your certification from docs. Make sure that you have a copy of that in case the prosecutor decides to file a Court of Appeals leave application. And also in Madison County, we have argued that the defendant can affirmatively waive the appearance in your county court to be released. So the district attorney actually pushed back on that because we could not get our clients available for an appearance. What you'll find in some of the women's correctional facilities is they can be administratively very difficult to deal with. And so we have argued successfully that defendant can waive the appearance, that they can firmly waive the appearance to be there at that hearing. So I think I covered everything. Okay.
Sorry, I wanted to cut you short. Thank you. I kind of warned everyone that we had a lot to say in this segment, and I just really want to get to our next speaker, Karen Portlock, who's going to talk about the developing case law and how the courts are wrestling with the statute, present company included.
Thank you so much, Judge Fisher. Thank you all. It's such a pleasure to be here. I'm really honored to speak with you and just to participate in this work. I'm a partner at a law firm in Midtown Manhattan, so far from here, but have the great privilege of partnering with Kate Mogilescu in this work. And so we had the chance to do an appeal under the statute and have delved into the case law, and we'll just give you a little bit of the lay of the land as far as the three prongs we've been talking about and how the appellate courts are wrestling with some of these prongs. This is a new law, so there's a lot that still needs to be developed, and we do anticipate that the Court of Appeals will be making some rulings that will give some further guidance to practitioners soon. So those three prongs again are first that the applicant was a victim of domestic violence at the time of the offense, so we'll get into that. The second one is that the abuse was a significant contributing factor to the offense. And the third for the court to consider is whether the sentence would otherwise be unduly harsh. So you can see just in terms of the framing of these prongs that there's significant discretion to the courts in terms of how they rule on these applications. So judges have a lot of discretion here. Turning to that first factor, that the applicant was a victim at the time of the instant offense. So we've seen significant case law development in this area. And what seems to be happening in the law now is that there does need to be a temporal nexus here. Okay, so we were talking about earlier, what does a successful applicant look like? Again, it's very case specific, but someone who experienced abuse many, many, many years ago and cannot connect that abuse to the instant offense, the offense that the court is looking at, that's going to be potentially too attenuated to be successful. So what we're seeing in the case law is that there is a concern sometimes applications that are not being successful, there will be that remoteness. And so successful applications tend to have a greater connection between the actual abuse and the offense, or in fact, the offense was committed in the act of an abuse. There was actually an act of abuse occurring. That might even be the classic case that we're seeing that can be successful. So when you're thinking about what might be a meritorious case, looking at this first prong, it's trying to bring the abuse closer to the time of the offense. That's what we're seeing as far as making those applications successful. We're also seeing case law speaking to the abuse being ongoing at the time of the offense. So again, if the abuse happened, but it's no longer happening, that may be disqualifying. Again, it's case specific, but really trying to present these applications to show that the abuse was ongoing, this person was a victim, and that abuse continued at the time of the offense is what seems to be critical there. Although I would note that there has been case law to clarify that the victim does not have to be in an episode of domestic violence, so it doesn't have to be within the throes of an episode. But again, trying to limit any potential attenuation between the abuse and the offense itself is really what we see as being important for successful cases. Turning to one other point here, there has been some discussion in the case law about mutual abuse. So situations where the victim can establish that there was abuse that they were suffering, but there's also information showing that the victim was committing acts of abuse or violence, that it sort of went both ways. Okay, we're seeing that, and we're seeing situations where prosecutors are saying that that should be disqualifying. We have some good laws showing that it's not disqualifying, but again, this becomes a complicating factor. So we want to sort of look at the full picture, and sort of like level with the court about what the full picture of the abuse looked like, but understanding that at least so far, there's some good language in cases showing that mutual abuse is not disqualifying, but making sure that you can establish that your applicant was a victim of substantial abuse at the time. We talked a little bit about significant contributing factor. What I can say there is that there's really a lot of questions about what qualifies. And so we can see that, as Kate said, it's not about justification, so it doesn't have to meet that bar. But there's quite a bit that needs to be developed in the law here. So I think it's really answering the question that Kate presented, what brought this person to this moment, and trying to answer that for the court in a way that really connects the abuse to the offense. And so when you're putting together your applications, really, really telling that story with completeness. And finally, on the prong of unduly harsh, this is one where I think there is sort of just incredible judicial discretion, and one where we see a lot of factors coming into play. Factors relating to the individual standing before the court. How is this person doing? How have they been doing while they've been incarcerated? Are they ready to reenter? Sort of the full picture of that person, but also looking at the circumstances of the crime itself. And so obviously being very educated, not only with how the applicant looks to the court at present, but also being able to anticipate any challenges about making out this prong with respect to, any aggravating factors around the offense itself, because that will be considered. I will say that there has been law in the third department about this prong. We have seen prosecutors in a case that we were fortunate enough to argue contend that relief was not warranted because the applicant already had a plea deal, and the prosecutor's position was that the plea deal already factored in the domestic violence, and it was otherwise a good deal for this defendant. But the law does not allow that, and we got a great ruling from the third department on that. So really what the DVSJA authorizes is truly a fresh look. It's truly a fresh look, okay? But it doesn't allow you to ignore what actually happened at that time. So being aware that presenting what the applicant has experienced as far as being an abuse victim, but always being prepared to speak to the crime itself, because those circumstances and those considerations will be brought up in the context of this application as well. So there's a lot to cover here. I'm sure there'll be more in a part two. We're grateful to the courts for and for this opportunity to speak to the issue, and the courts that have so thoughtfully engaged with the statute. So thanks so much.
I appreciate you talking very quickly through that because of the time, but I do want to just repeat again that the materials that were provided for the CLE really are a great list of cases that will give you everything you need in terms of how the case law is developing. And you can look at the facts and see how the facts and that the courts have played with those facts. For those of you that are remote, virtually coming in through the Teams, the code is 4JD. So that's 4, the number 4, and JD as in Judicial District. Now it's time for another comfort break, and I'm going to continue collecting questions, and then we're going to come back for our last panel. And then after that panel discussion, we'll have questions. So thank you. Into the workings of the Act and the impact on the practitioners, victims, and judges. We have my colleague from Ulster County, back in the day when we were together at the Public Defender's Office, now Judge Brian Rounds, will join Karen, Kate, and Lisa on this panel. Judge Rounds, I'm going to start with you because you had a very interesting and perhaps unique DVSJA experience. And I know you have to be careful about what you say about an actual case, and you can't mention the names, but you could just give us a gist of your unique case that you had under the Act.
Okay, I'm going to sit if that's okay. Can everybody hear me? Okay. Look, it's 4:15 on a Friday. And the speakers so far have been incredible. I've learned so much. Thank you. You're all great. But I feel like I have so little to say now. So some of what I'm going to say, I think, is sort of, I hope, validating and emphasizing some of the things that you've already said. I did have an interesting case. I do have to, be careful, as the judge said, about using names and whatnot. I've actually had, I'm the Ulster County Court judge, by the way. And just for a little bit of background, just so you know where I'm coming from. I started out as a law clerk for 3.5 years before I was admitted to the bar in the Albany County District Attorney's Office. I worked for free. Mike Connolly is here in the audience today. He's one of the smartest appellate attorneys I've ever known in my life. He was second in charge of the appellate division while I was there. And while you folks and Professor Lynch were talking about 1994 sort of being a dividing line, I graduated from Albany Law School in 1994. And the first thing that I did in the first day I worked there, a former chief assistant district attorney and one of the main homicide prosecutors in the office, Mike McDermott, who I learned a great deal from, put a picture in front of me. It was a guy with his head blown off. I mean, literally from here up, as the pathologist would later describe it. And he had been set up in a robbery. And it was May at the end of my first year of law school. And that's the first thing he showed me. If you want to have any idea what kind of weird kid I was, I said, was it a 12 gauge? He said, yes, it was. But the reason I bring it up is because the victim was shot by a man, but the victim was set up by a woman. I remember her name. I just wrote it down a minute ago. Can't say it to you because, as I recall, it was a successful defense. The first thing I did for Mike McDermott was I went to the library and I got out a whole bunch of books on something called the battered woman syndrome. This is 1994, mind you. And I dived into it, was fascinated by this subject. And the reason that I was doing it is to help the prosecution counter the duress defense as supported by a battered woman syndrome defense. She had been the victim of abuse of the person who actually blew the guy's head off. So from the get, for whatever reason, I was fascinated by the subject, and I think I did a pretty good job with it. Then I spent a little time in Albany Police Court, the emergency room, as we called it. And then my first job as a felony prosecutor, I was actually, I'm proud of it. I was the first assistant district attorney in Albany County to be called a felony domestic violence prosecutor. I volunteered for the job. And I wish Professor Lynch was still here, because one really cool thing that happened to me, I started out in the DV unit prosecuting cases that weren't victim dependent. I built cases against abusers that didn't require the victim to ever testify. And one of my interns one time showed me some case materials from Professor Lynch's class, and a couple of my cases were in there. I was pretty proud of that. So that's part of my background. After being an assistant DA for about half a decade, I was then a criminal defense attorney for 20 years, and I became a judge in Ulster County back in 2020. That's just a little bit about my background so you know where I'm coming from. So I'm just telling you that I have a completely open mind to the subject matter. I have been involved in the subject as a prosecutor from the beginning, and I had countless clients who were either accused of acts of domestic violence or themselves were victims of domestic violence. In any event, the case that Judge Fisher brought up. So I think I've gotten 2 applications so far under the Act. The first one was a denial for an insufficient showing on the papers. I'm not going to talk about that one. But the second one, I granted a hearing. As somebody mentioned, if the requirements are made out, you know, that there endeth the judge's discretion, right? I mean, if the boxes are checked off, grant the hearing, because it says shall. And when a statute says to a judge, you shall do something, no matter whether the judge likes it or not, and I'd have no problem with it, you do it. So we had a hearing. And in this particular case, the person who was convicted of murder was not a woman, as is often thought of when it comes to the Act. It was a man. And there was a long hearing. We had 2 or 3 days, separate days of hearings I set aside in a busy courtroom. And to summarize, because I only have so much time, basically the picture emerged of his father being a mean bastard over his entire childhood. He appeared to take great pleasure in demeaning him. He touched him inappropriately. And he did so apparently to a sibling. The abuse also included demeaning behavior toward his mother. Like, for instance, at one point his mother used a walker, right? He seemed to take great pleasure in taking the walker away from her. You know, real sadistic activity. And long story short, very long story short, there comes a day, oh, I should say this because it's directly related to the temporal proximity issue that is a huge part of the questions that are going to go before the Court of Appeals on all these cases. The abuse really ended in his childhood. And by the time he gets to adolescence, it's tapered off. Is he still a mean, you know what, when they go for family dinners and whatnot? Yeah. Has he become a nice soft guy? No. But it's pretty much tapered off. Then what happens is there comes a day when he allegedly learns that his son was touched inappropriately by his father. About a year prior to the event that I'm going to talk about. So he learns this, and sometime later, it's bothering him. There's some signs, and again, I'm summarizing. Time goes by, and one day he murders, according to the jury, there's a murder conviction here, he murders his father. Brings an application under the Act. All the prongs are there for a facial showing. He's getting a hearing. There was no ongoing abuse at the time that the event occurred. So I'm a county court judge. How many of you are not lawyers? Because I think that we have a tendency, because we're all lawyers and judges, to talk to lawyers. How many of you are law students? Okay, all right, thank you. So basically, as you know, I'm sure, I'm a county court judge. I'm a trial level judge. My responsibility first is to see if there's any controlling case law, right? Specifically from the Court of Appeals and definitely the Appellate Division, 3rd Department. That's the law as I understand it that I have to follow when I apply the law. My opinion on that is irrelevant. I have to follow case law that's controlling. And we've got good case law. When I say good, it's not an assessment. I'm saying we have a body of case law in the 3rd Department. So faced with the situation, I look to the Appellate Division, 3rd Department. The statute does not, this is a quote, does not require that a survivor prove that she was defending herself in an episode of domestic violence, like either duress or justification. Let me start with that and reemphasize what I think needs to be reemphasized, just in case anybody misses this. Justification is justification. It's a defense. It's a complete defense to any violation of the statute, not just murder. Justification applies to a speeding ticket. It's basically society saying this harm that we're trying to prevent by having the statute is not as bad as what could happen if you don't break the statute. Most people think of self-defense or defense of another, but it really applies to any statute. Duress. I did something because someone else was making me do it. That first case that I talked about that I worked on when I first was an intern in my first year of law school. I was under the duress of someone who was a batterer, and that's why I set up the guy in the robbery. Extreme emotional disturbance. Yes, I killed someone, and no, it wasn't justifiable, but I did so under an extreme emotional disturbance as defined by the law, without getting any detail. Those are all defenses that were already in place before the act. Now, I bring this up because what happens when the application is made and I grant the hearing, the very first thing that the Ulster County District Attorney's Office says in court is collateral estoppel, res judicata. Why? This case was tried, there was a mistrial, and then it was tried again. And there was a conviction. And no defense of justification or extreme emotional disturbance was successful. This is collateral estoppel, it's res judicata, and just for good cause and measure with all of the victims, family in the courtroom, as is always the case, usually the case in these hearings, both sides, you know, you're putting them, by going forward with this hearing, through trauma a second time, right? Well, on the res judicata collateral estoppel, I didn't need to check with the law clerk, ruled from the bench. I mean, this is why it's so important to reemphasize what was said earlier, okay? First of all, the statute didn't even exist when the trial took place. And secondly, there is no collateral estoppel or res judicata, in my opinion, that I rendered in this case, because this issue hasn't been reached. This is a sentencing issue. It's not a merits of the case and a defense of the case issue. So anyway, that's the very first thing that a judge will, I assume I'm not the only one, will have to deal with. First thing is, you got to look in the room and you got a whole bunch of folks who have a loved one who was murdered. And the district attorney says this hearing should not even be allowed because this has already been decided by a jury. You had a mistrial and a full airing of all these issues, and you have to explain as best you can because one of the issues that I saw that was in the roadmap was what are the ethical considerations, right? I don't know if it's an ethical consideration, but it's a human consideration to try your best as a trial judge to, whether someone disagrees with you or not, try to explain why you're doing what you're doing. Because a huge part of justice, in my opinion, is the perception of justice. It requires buy-in. And where you can, explaining why you're doing instead of just announcing it is a good idea. In any event, we got over that hurdle. And now we go through 2 or 3 days of testimony. You remember what the facts were. Also, there was a really, really smart judge in the Appellate Division, 3rd Department, who said the following in their written decision, People v. Liz L. A very enlightened judge who spent a huge number of years in family court, who's very familiar with the issues, who is certainly open-minded, said the following, quote, "To be sure, the statutory language must create the requirement that," and I italicized here, "some temporal nexus exists between the abuse and the offense, comma, otherwise it would be rendered meaningless." And also citing a case, a New York Court of Appeals case and an Appellate Division 1st Department case. And another Appellate Division 1st Department case. And not to confuse the justice to whom I'm referring with another case that has the name People v. Fisher, the Appellate Division 3rd Department affirmed a county court's denial of a CPL 440.47 application based upon the defendant's failure in part to sufficiently establish that she was abused by her father at or near the time of the offense. And then the Appellate Division further stated, in another case, People v. Brenda W.W., 3rd Department, 2023. The statute requires a showing, quote, that such abuse was, and I believe the last speaker, one of the last speakers mentioned it. You said there's some language out there. Here it is. Such abuse was ongoing at the time of her criminal behavior. Now, again, a judge who denies an application because at the moment in this case, murder took place, the defendant was not being subjected to immediate physical abuse is not the controlling case law as I understand it. Let's put it that way. And that's certainly not what I found in my decision. By the way, before I forget, somebody mentioned, one of the presenters mentioned, because there's a lot you guys mentioned that I would love to talk to you about. We'll have to talk about it afterward, how important it is to make a record. I wrote a 25-page decision in this case, and pages 3 through 15 were just findings of fact, because I wanted to make it as clear as possible what the court found on the record, and any reviewing court could then take a look at it and decide whether what I'm doing is in line with the precedent that they've already pronounced. And then, of course, if it goes beyond that, to say the Court of Appeals. In any event, those are some of the issues that we dealt with in the case. There are other very interesting things that happen when you actually hear one of these cases. Let me tell you about my case, for example, because I told you that the picture emerged of a father who was somewhat of, I think it's fair to say, not the nicest guy in the world. There's other weird facts in the case, though. On cross-examination, because remember, there's a full hearing, the defendant testified. So did family members of what they'd observed over the years, over 2 days or more. At some point, the defendant's brother disappears. This is before his father's murder. There's a huge search team, police. They're all scouring the woods of a place called Highland, New York. It's in the southern end of Ulster County. They don't find him over days. According to the defendant, both in prior paperwork that came into the case because of the investigation regarding the death of his brother, and the defendant's responses on the stand, the defendant's story, the one whose application I'm considering, during the hearing, is the following. His brother disappeared. There was this huge search party. The police and a big search party, and dogs and the whole deal failed to find him. But one night, he gets hammered drunk. And he just decides to go out in the woods alone, in the dark, drunk. And he stumbles across his brother. And his brother is hanging in a tree. And according to him, he cuts his brother down. And then, according to him, he strings him back up. Alone. And then days go by and he doesn't tell anyone because he doesn't want him to be found. Those are facts that came out in cross-examination during my hearing on the act. The questions that go to the defendant's credibility. I made no findings of fact in that regard. But yeah, I see some faces going, that's interesting. And one could speculate, which I can, a million different reasons why that story would be in place if one's conscious of things like evidence. But in any event, what that led me to think about as we were preparing this, we had some meetings, and that led me to think about, and I did talk in the decision, quoting I won't make any motions, quoting the appellate division, 3rd department, and some of the statements they had made about temporal nexus being a requirement. And I talked about the old saw about how exceptions can swallow the rule. I don't know if the legislature or even everybody involved in dealing with the act understand that if there is not some temporal nexus between the abuse and the crime for which the person's convicted, I don't think that there's a real true appreciation of how many, or better yet, what percentage of cases are going to be affected by that. Let me just tell you anecdotally, I'm almost in 5 years on the bench. First of all, particularly when it comes to women. My anecdotal observation is, and it doesn't surprise me at all because I represented women in felony court for years, 2 decades. The vast majority, it is the exception to the rule that when a female defendant in particular appears in county court, it's the exception to the rule that they don't have a history, not just of abuse, but sexual abuse, which shouldn't surprise anybody. Because the last I knew, the statistics in America are horrifying for that. I think the last I knew, 1 out of every 3 women by the time they reach college age is the victim of a sexual assault. And then when you're talking about the population of women who have committed a felony crime and they've been sentenced to one, I would say easily 75% of the women that appear before me have a history of sexual abuse. And it's not limited to that. The men, it would be the exception to the rule that a violent defendant who's convicted of a violent crime in front of me does not have a severe history of certainly emotional, sexual abuse, and was subjected to violence. It doesn't mean that someone who's subjected to those things as a child will become that thing. But show me someone who's committing violent acts, and I'll show you a high percentage probability that they were in a less than safe environment growing up. And I think one of the concerns that temporal proximity meets is the over-application of it. I have some other examples, but I'll.
Yeah, we'll save time. We could talk about this for a long time. Thank you. Thank you. That case sounds very interesting, and I made a note to myself because it was made, I wanted to mention it earlier, someone talked about counsel making sure at the hearing they make the record, and then you repeated it again, the record is your best friend. Everyone, no, I can never say that enough, make a record of everything. Now, next, I'm going to ask the remaining panelists to discuss this, and I'll let you guys all jump in where you see fit. I wanted to talk about how the act affects the victims and the surviving family members, and what are the competing interests and the responsibilities that the prosecutor must navigate and the other attorneys advocate. And we all talk about also, we're all trying to be humane in this process as well. So this is kind of an open discussion, and I don't know who wants to take a jab. Lisa wants to take a jab first. Go ahead.
Thank you. I think that this is a really important topic, and I know that Kate and I have worked on a number of cases, and this is someplace that we certainly start from and agree that there has to be respect for this process in all sides of it, because at the beginning and end of the day, a horrible crime happened, and it, as I said earlier, we can hold 2 things that can exist at the same time, that somebody is making allegations, is making an application for relief because of a horrible trauma narrative and abuse. And a crime occurred. And oftentimes it happens to somebody that was outside the confines of what the DV relationship was. And I think that if we as prosecutors and we as defense attorneys can appreciate what each other are grappling with and the responsibilities that we have, that we can really handle this in a more human, I want to say humane, but it's really human way, because these are people and these are their lives. It's our jobs, but it's their lives. And so I will spend just a moment, because I acknowledge that I'm a little bit out of my depth, but when I see a case come across my desk and it's filed and there's like actually no temporal nexus, or there's actually no 5/30/11 relationship, and I call up somebody that I've worked with and they say, well, Lisa, I was assigned this case. I think that there's a passing the buck, well, I'll file the motion, I'll see what happens. And there's a lot of damage, there's a lot of fallout from that. You know, that motion that might be cry out for relief, but is misplaced under the DVSJA, and we have to push back. There's the same thing, even when it's merited, but particularly when it's not, we have to make difficult phone calls and have difficult conversations with victims and their families. And I will just say that, you know, it's a really unenviable task to pick up a phone. And by the time I finish saying, this is Lisa Perlman calling from the Brooklyn District Attorney's Office, I've blown up, you know, the surviving mother or sister or niece of, you know, I've blown up their day, and I've blown up their week, I've blown up their world. You know, I'm ripping off scabs of wounds that have not ever going to heal. And even when I need to make that phone call because somebody really does deserve this relief, this is, you know, really wrecking somebody's world, and it's creating and reigniting trauma. And I just want to mention that, and I hope that Kate will talk about, you know, what we can do on our side. I can tell you myself that when I have to cross-examine a defendant, when I don't believe that they are meriting of relief under the DVSJA, it would not be my style to start challenging their allegations of sexual abuse in their childhood. You know, we're not going to do that. And I hope that you will hear what I'm going to talk about, just sort of list out some examples of places that you can factor that in to either bringing a motion, and certainly if you're encountering family members in a courtroom, or if you need to cross-examine victims or victims' families that are filling in some of the narrative in the course of a 60-12 hearing. You know, there's of course the pain of the crime and the pain of losing a family member. If it's the victim of a crime, you know, very few of these cases that I've dealt with are not homicides. We don't often have the victims, but I do have a case where there's a victim. And if it's a hearing that we don't believe that it's the, you know, that relief is merited, I have a situation where they're being recast as the abuser, or a surviving family is watching this play out where their loved one, right or wrong, is being recast as an abuser. And very quickly, I will just say, you know, in a very self-deprecating way, that once I had a case where the fact pattern was so terrible and the allegations against the abuser, he was a horrible person. He was stringing the applicant along on drugs and withdrawing the drugs and controlling her and abusing her and keeping her hostage. And eventually she participated in a robbery that led to his murder. And he was such a despicable person that I almost slid out of my desk chair when I got a phone call and from his daughter, his 50-year-old daughter, that said, I heard that my father's killer is being released from prison. And he was leading I couldn't even, my father was the greatest man, and I can't believe this. And I had to say, oh my God, I've got to really check my own biases. But even the most despicable people have, you know, grieving family members. But in all events, whether the relief is merited or not, we're dealing with people who are feeling a complete loss of control because they had believed that there was some finality to the case, whether it was through a plea bargain. And that's why I said earlier to come to the prosecutor in open cases sooner than later, before plea bargains are discussed. there are family members that can't let go of advocating and pushing back because it's the only thing they feel that they can do for a lost loved one. And acknowledging that's all they feel that they can do. And also particularly in the context of a resentencing, as I said before, I've met amazing, resilient people that have obtained multiple master's degrees and done every program and are the most rehabilitated people. And when I call somebody, a family member 20 years down the road, they remember the person that was sitting in court 20 years ago that hadn't accepted responsibility, that was addicted to drugs, that was pushing back, that was maybe acting out in court, and they're scared. And the idea that they're going to be released is not only outrageous to them, but it's scary. So I say all this because I think that we should have an understanding and appreciation for the trauma. If there are prosecutors, I don't know if there are too many prosecutors in the room, but I've said this in other trainings that I've done, appreciate this when we're prepping our witnesses, when we're having these really, really difficult conversations with them, even in cases where we're consenting, we still have to have these conversations. And keep in mind also that sometimes a plea offer in a case where there's now a hearing taking place, part of what our consideration was in extending a plea offer was because we had witnesses that didn't want to testify. And now we have to call them to testify at a 60-12 hearing. That's really trauma that brings up facing a defendant in the courtroom again. And that's scary because they have a memory of a very different person sometimes not, in cases where we don't feel that the defendant is that deserving applicant. And I think that it's just an important insight for us to all appreciate.
Thank you.
So I think if you'll remember when I said we need to take a collective deep breath about this and return to the fact that this is about what is an appropriate sentence in any given situation. And it's not about having full-blown trials to determine a sentence, as Lisa just said. It's about opening our frame and rejecting what we have sort of accepted as true, which is that she represents the good people, right? And the people that have been harmed, and I represent the horrible people, and that everything exists in a binary, because what the reality is that the harm is multidimensional, it's 360 degrees, and we can't separate people so easily. And the DVSJA just says that let's take another look. Let's not say 15 to life, 25 to life automatically and agree 15 to life is a good deal and 25 to life is the maximum, and leave it at that there is some nuance here and we can appreciate that, and we can detach ourselves from an allegiance to these sentencing numbers that, again, how many of you were taught felony sentencing by a chart? You were just handed a chart, right? And you know, if it's 3.5 to 7, we're dealing with a predicate. If it's not, all of it, there's no human being reflected numbers, just numbers. And there's no science behind those numbers. No one has ever shown that someone sentenced to 23 years as opposed to 15 years gets more or better rehabilitation, or people heal more. But somehow we cannot get away from the sense that these numbers mean something. And so the conversation that we have to have with people that are harmed about these numbers, then take all of that and reiterate it. And we recycle the same thing. And Lisa's not the only one that calls people who have been harmed by an offense. Defenders do too, and we need to, right? Because all of us are on all sides of this. And that is what the DVSJA gives us. So I really think that the more that we kind of say, we stand here and say, it's not justification, it's not, I said it. I led the whole day by saying it. But I'm bringing up the same way we do things when the DVSJA actually allows for things to be done a little bit differently. So that is the first thing. In terms of the ethics of this and the ethics of recognizing that there are people who have been impacted by the offense, right? We take that into consideration. None of this is dismissive of that. None of this. But the experience of the applicant, which we really haven't talked about today, of what it takes, whether you just were arrested 2 days ago and just were assigned counsel and are now expected
to articulate your abuse history in a way that is compelling, chronological, rational, reasonable, all the things, right? In a system that has silenced you, with a lawyer that might not be trained and does not have time to sit with you and develop this. And I can talk badly about defenders, but nobody else can in here, because I am one. In front of it, right? Where you're told, don't show any emotion in the courtroom, don't do this, don't do that, don't say anything, don't turn around and look at your family, don't do, right? You're told all of these things, and the expectation that someone could then articulate their experience with abuse in such a way as to show temporal nexus and significant contributing factor in a way that satisfies us sitting here is preposterous. It's not reality. So let's take a deep breath again and think about what we can do in the context of this law and what this law could allow and how we could approach it differently. You've heard a lot about temporal nexus. I would just ask one question about that, which is, when does someone cease being a victim of an offense? When does trauma stop? Yes, it is not the case that the DVSJA says anyone who experienced harm as a child 40 years later can come back and say, I need a lower sentence. But we have significant contributing factor. There are ways to analyze this. So our collective sort of panic about that and about the floodgates that might ensue, one, hasn't been borne out, like that has not played out. No court system in any county has been crippled by the DVSJA. Right, we've all gone on our merry way. Arraignments keep going. Everyone, right? Things keep rolling. Judge Rounds has had two applications. Okay, so like let's just start there. But the other thing is that to ask people to come forward and share this, right, and not recognize that the applicants themselves are often also grieving and have again caused significant harm. Some of the situations that we encounter in these courtrooms are terrible, but applicants themselves are grieving, and they're grieving maybe the loss of a loved one. They're grieving, just reckoning with their own experience. And so if we could all just sort of think about it that way, instead of what we've seen very troubling in a lot of trial courts across the state as we've confronted this, is a hostility towards applicants, a sense that people are trying to just take advantage. And even if in the worst extension, right, people are filing resentencing applications or asking for 60-12 hearings and they do not merit relief. What Judge Rounds just said, right? Every single person that is appearing in front of you in court has some trauma history. And for us to be cognizant of that and be a little bit more, and rather than, and I'm not suggesting you did this, but I know what we're seeing in other places, rather than eviscerating the applicants by virtue of them seeking relief. There are a few more things I could say, including just that we may also be reading requirements into the law that are not there. So we've talked a lot about the institutional record of people there, whether they have disciplinary records and whether we should make a chart for Lisa or not, if we should, right? Which we've done, I've made her charts before. But that's not in there, right? It's not necessary. It's not required that someone show rehabilitation. That's not what this is. And it's also not necessary that someone must even come in and testify, right? The statute allows for other evidence of abuse to come in and avoid someone having to be cross-examined about their brother's maybe suicide, right? The cross there, to what end? To what end? So I think we may be inadvertently or advertently, depending on how cynical you are. I'm pretty cynical, but I don't know where you all fall. Reinforcing a perfect victim expectation that if we read about it in an article, we would agree, we'd be like, so, right? But then when we actually are in a court dealing with it, we somehow can't get past ourselves. So I guess maybe that's what I meant when I said we should take a deep breath and think about this really as sentencing and an ability to address harm. And we have seen, and I know everyone has talked about Mike Connolly today. Mike, you're a very, very prominent part of this CLE. But Mike and I had an experience in Albany County Court and a resentencing that the Albany County DA's office agreed to that really embodied what the statute could be. It was a moment of healing and recognition. And it was a significant sentence reduction. It was from 25 to life down to 15 years, which was time served. but it was a recognition of someone's experience. And we did all the things. We did all the things that we talked about. We talked to family members. We engaged with the harm. And so that's what we need to see. Maybe less of the cross-examination. I'm sure I have more, but I want to make sure that Karen has an opportunity to talk also.
Go ahead, Karen.
Oh, this is such a powerful and important discussion, and you've heard so much wisdom. I wanted to share two things. I mean, one is that I do come to this work with a background as a federal prosecutor. So before I returned to private practice, I worked at the U.S. Attorney's Office in the Southern District of New York. And I will tell you, as you may know, that there is absolutely no counterpart to the DVSJA in the federal system. This is just a tremendous opportunity to really get that fresh look at an applicant and to really think about what is just. And for that reason, it's just an incredible tool. So I think for everyone who's sort of considering how to incorporate this work and what opportunities there might be, this is really a powerful one that is unique in New York State. It's just tremendous. I think also to pick up on the points that were discussed, there is so much trauma. There is trauma on all sides, no matter which table you're sitting at. There is trauma for the judge. There is trauma for the prosecutor. There is trauma for these attorneys. This is really heavy work. And so just being cognizant of sort of the emotional responsibility of taking on these cases, I think is something you got to do, in order to be good at it. This is work that draws on our humanity, but we must dig into that well in order to be successful, right? And the last thing I just wanted to offer, to the extent that there are folks who are also in private practice who are seeking to assist in this work or looking for opportunities to just get involved. I mean, Kate's organization and, so many folks are offering opportunities in various ways. But I work with teams of lawyers, two of whom are here today, Vanessa and Brian, and all of us at the firm are just so grateful to have the chance to do this work. But, this provides incredibly meaningful and substantive opportunities for lawyers throughout their careers, really, to just get involved and make a difference. I did want to note, as part of the ethics discussion, that we do often see, other issues in working with clients when we're seeking to understand their domestic violence history. We see issues of substance abuse. We see issues of other forms of trauma. We see issues with poverty, with just life challenges. So we try to also be cognizant, and we'd obviously, as part of this discussion, encourage those working with these clients to be cognizant of the range of issues that these survivors are facing and their families, and trying to sort of identify appropriate ways to support them, while also focusing our work on building, a meritorious application. So again, but I do think, to end the conversation, we can be on an optimistic note, because this is really just a tremendously powerful tool, and one that we should be grateful to have and to use.
Thank you. Thank you. We are like right on time. So at the risk of going over, I would like to, there are some questions that are being asked, and I'd like to take some questions, but I'd like to give out the code for those people that are appearing virtually who may not need to be able to stay on for the questioning. So GFC for Gender Fairness Committee, G as in gender, F as in fairness, C as in committee is the final code you need. I'm also going to invite Judge Coffinger to come up to help me with the questioning and to say some remarks as well. But before I do that, I just would be, I have to say one thing. I didn't mean to imply, and I hope no one takes from this, that we're imposing additional requirements on defendants for hearings. My encouragement to create a record that is very robust is because of the fact, and I'm very delicate when I say this, you don't know who is going to be presiding over your matter. And I think everybody comes to the table with a different perspective. And I think your best shot is to throw everything right in that you can, right? So I don't think we're trying to make additional requirements under the statute. I just think we're trying to say, this is your one and only shot, so make it good. Okay, Judge Coffinger.
Thank you, Judge Fisher. What a wonderful program this has been. And I think many of you could probably agree with me that we could have made this an all day and still not had enough time with all of the experience that's sitting up here. I'm a family court and county court judge, and I also had 2 of these applications, but they were not properly submitted and they didn't have the right elements. And I think they need Veronica to get in there and really get to the details, get to the heart of the matter, and maybe they will on another opportunity. And I'd also like to say, I see Professor Lynch is still on. In 1996, there was a clemency proceeding that the domestic violence clinic here worked with. And it was in the promotional materials that led me to come to school here in 1997. So I'm kind of fangirling with Professor Lynch here because I feel like I've come full circle now in my entire career. She got me in the door and now I'm listening to her and I'm doing the work that she actually led me here to do. So that's kind of cool. A lot of the other things, I'm writing down little tidbits as the speakers were saying. Start by believing. Start by believing. I think that's a big hurdle, not only in criminal court, but in family court, because there's a lot of interlap between the 2 courts. One often leads to the other, and talk about looking at the record. Family court is often a great place to find records that will support these kinds of applications between the paragraphs. Those are the kinds of things that you need to really look at and to dive into that will get us into where we need to be for these applications. I know that there were some questions online here. I'm not sure if we have enough time to get to these, but
I can read them out if we have time.
there's a voice. Oh, go ahead. Yes. I thought the heavens were talking to me there.
So I think we have time for a couple of questions.
Okay.
I think maybe if the panelists could speak to some of the trends you might have seen in successful DVSJA applications. Are there some examples of maybe particular kinds of crimes that a domestic violence victim might have been convicted of, where they would be eligible, or maybe have successfully obtained sentencing or resentencing? Are there trends maybe that you've seen in the data? And kind of following up on that, can you speak a little bit more about what maybe re-entry planning could look like in some of those successful applications?
That's a
Was
lot
there
of
anyone?
questions, but anyone could talk about the trends? You can huddle. Oh.
Yeah, I think one point to make is that what we have seen is, as I shared at the beginning, that with the successful DVSJ resentencing cases, and we don't have a lot of information about what's happening at the front end. There are a few cases that have made their way up, and so we're starting to see more of that, but there is no comprehensive tracking the way that we are able to look at the resentencing provision. So we're able to take lessons learned there and sort of forecast that onto the front end. But as I said, half of the successful resentencing cases that involved a victim that was not the abuser themselves. So we're seeing coerced participation in robberies as a pretty common scenario. We're seeing felony murder as a pretty common scenario. And then when the abuser is the victim in the case, what we saw, and we've seen this right from the beginning, some of the very first successful cases and some of the very first appellate cases involved the homicide of a parent. And here there's a very strong connection between people who are prosecuted as young people for causing the death of a parent and severe abuse in the home. And so there are 6 examples of that within those 68 cases that I mentioned, which is significant, I think, of people who were convicted of causing the death of an abusive parent.
Do you have like on your website or something, a list of these
Judge.
cases?
Oh, Judge.
Oh, Judge.
I know that if we had funding,
Yeah.
we would be able to get a lot of this information out there. We've been collecting and collecting. We're trying to make it accessible. We're building that part out of our website, but we are a very small and scrappy operation. We're a grassroots collective, the Survivors Justice Project, and we simply don't have the capacity to do everything that we want with this really critical information.
That's unfortunate.
Can I just add
Sure.
quickly to that, I think I mentioned earlier that I've probably looked at like 30, 35 or more of these cases in Brooklyn. And what I start to hear myself saying to myself is, oh, this is like a classic DVSJA case. And that is almost like an oxymoron, but
Right.
I think that's the sort of part of the question that's being asked. And I will start by saying I am a prosecutor and there are just cases with co-defendants, and both co-defendant, each co-defendant is violent and they are doing violent things. That said, when there's an allegation that there is an intimate relationship between the co-defendants, that's a place to start looking, because like the classic case that I'm thinking of is that it should have been a duress defense, actually, and the way I explain it to colleagues is that coercive control, if somebody has that coercive control over somebody, that level of duress will not look like a gun to their head. It will look like grab the knife and stab them also, start cutting up the tape and passing me pieces of the cord to tie them up. And that could just be like a classic case of keeping it I don't want to escalate. I don't want to set them off. I don't want to escalate this. So it could be hand me the remote control, or, hand me a murder weapon and participate in this murder. And then what sort of kicks it into high gear is that this is a person that doesn't need to threaten them because they've been abusing them physically, sexually, and or psychologically for years. And then they're watching them do this violence to another person in real time. So that's just sort of the next level of that significant contributing factor, because I've certainly heard, not only in interviews with the applicant saying, well, I thought he was going to kill me. That's a reasonable belief because he was hitting that person over the head with a baseball bat. And if I didn't do this, I knew he was going to, because he's shown me over the past that he was capable of hurting me and he was hurting somebody else. Sometimes we hear it in taped jail phone calls that say, I thought he was going to kill me. So I think that dynamic plays out, and that's something to look at, presupposing all the factors that I've laid out.
Does anyone in this room have a question? I know we had some, and say hands. Oh, there we go. We'll just wait for the microphone so that the people online can hear you as well.
I'm going to try to make it short. How do you deal, maybe this is to the judge, with confidential information or information about sexual abuse? I don't know, does that become part of the record? Do you, block it out? That's one question. The second question is, are courts believing expert testimony about causation or contributing factor any better than they did with battered women syndrome? Because the battered women syndrome didn't do too well. And how about lesser crimes or nonviolent crimes, or patterns of criminal activity that might be associated to trauma?
I can start with the first one. If it's testified to in court, it's part of the record. And it does get testified. I haven't had a motion for sealing. We've had psychologists testify. We've had all kinds of stuff that could potentially be subject to it, but it's in the record, and without a sealing order, it's part of the record. One of the things that's sort of related to that, though, that I turned to my colleagues over here and said, when the judge brought up, get those family court records, as a prior practicing attorney, I turned to them and said, is it easy to get those family court records? And you see what everybody's reation is.
Yeah.
It's
hard, but it can be done.
Right, but
It
it
can be
usually
done.
involves like,
Yeah.
buying chocolate for the clerk, or,
Filing an appropriate
donuts.
motion.
See, donuts, she just said it. donuts.
Filing an appropriate motion will have to
What
do
was
it.
the second part of your question? Because this part two.
About expert testimony, because in my experience, but this is way back when, the battered women's syndrome testimony didn't always go over very well. And I'm wondering how expert testimony goes over, and what kind of expert testimony you heard or not heard that would be credible.
personally, I think you could tell, I have no problem accepting such testimony. However, before I forget, it's a good time to, if you wanna, there's been a lot of talk about ghost of
Christmas past.
Christmas past and future. I think if you are into this
You're present.
topic, Adamanda. People v. Adamanda, 197, 83rd, 106. This was the first application by a trial judge. It was in Dutchess County. Just read it. That's all I'm gonna say. Just read it. It wasn't an appellate division, third department case, but you want to read that. To me, that case and that decision, if you want to look for a real dividing line about how people used to think about domestic violence and where I think most people are thinking about domestic violence, that decision is probably a good place to start. The lower court decision, and then the case that I just said was the appellate decision overturning the judge's decision. In sum, she could have won. The lower, in sum, right? Is that a fair summary?
Yes.
She could have left, right?
Yes, yes. And that
And
was.
this is
that was-
Professor, oh, sorry.
What's that?
Just Professor Lynch was going to agree with Judge Rounds, but also say that, Professor Hutter, who from Albany Law, who does some of the evidence, we have these conversations, and I'm constantly surprised by how courts continue to use words like battered women syndrome when that's no longer the dynamics of domestic violence, coercive control, other issues like that we've expanded. And I think I understand why the courts are doing this, but I think as advocates, we have to keep pushing them in a way that the Adamando case and other cases have done to kind of stop with the outdated terms.
Sure.
Just to answer the question though, from a practical perspective, we're definitely seeing that there's a real place for expert testimony. So expert testimony speaking to, how the experience of abuse manifests, how to understand behavior. Like there's definitely a place for that. And we're seeing appellate courts reference that kind of testimony as being meaningful in decision-making. So I think can be valuable.
In my case, a psychologist testified that there was PTSD from the revelation about his son being abused.
I just want to add that from our perspective, if you're trying to get to a consent, that to the extent it's possible, and we acknowledge that, of course, domestic violence takes place behind closed doors, but to the extent that it's possible, if you have an expert's report that can do more than just comment on the defendant's own telling of their trauma narrative, if they can include, to the extent that it's possible, collateral sources, or factor that in, it helps. Because sometimes that's all there is, but when it's ignored, it becomes problematic for us.
All right. Unfortunately, we're running out of time. Like I said, we could have done this all day. I have a few things to tell you all. First of all, if you have questionnaires, please fill out those questionnaires. That helps us as we're making these plans for future programs. I want to extend my thank you again to not only the fellow co-chairs of the 3rd Judicial District, Gender Fairness, Judge Fisher and John Kerr, but also Narina Molina. There she is up there. She does a tremendous amount of work. And our co-sponsors, the Albany County Bar Association, the Albany Law School Government Law Center, the Capital District Women's Bar Association, Legal Aid Society of Northeastern New York, the NISBA Criminal Justice System, and NISBA Women in the Law Section, the Schenectady County Bar Association, and the Adirondack Women's Bar Association. Now I would invite everyone to join us for a reception in the foyer. Thank you very much. It's been a lovely Friday afternoon with all of you.